We'll call this meeting of the Board of License Commissioners of Carroll County to order. It's been a long-time tradition of this board that we observe a moment of silence for those who have gone before us and pledge the flag. It is strictly voluntary at this time. Mr. Harney?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You all may be seated. Ladies and gentlemen, the first item on our agenda is approval of the minutes from the July 13th, 22 board meeting, which you all received and has a copy, I believe, in this packet. Are there any corrections or additions to those minutes?
No.
No. Hearing none, they stand approved as read. Our next item is to look at a proposed changes to the Board of License Commissioners' rules and regulations. And we appreciate the attendance of those who are here. It was the opinion of this board, as we as a board discuss these proposed changes before we go to public hearing, in the essence of time, and primarily to those who are more familiar and work with these rules and regulations, that we invite you all and anyone who would be interested in, before this board makes recommendations to our final recommendations to our rules and regulations before we go to public hearing. So with that, Keith, do they have copies of the?
They have copies of the wording. If you guys want to come up to the tables. On the desk are copies of the rules and regulation changes. And then we have what you guys submitted to us by email.
Do we have all the emails and so forth?
Yeah, that's what's in your packet.
Well,
I don't know if I have emails.
No, they're just copies.
They're copies of what I was emailed. One looks like this. One page.
Is that, it says 16-1312?
Yeah, that's from Kelly Schaefer.
Then there's one that says rules at the top,
Yeah, that's from,
Marty
Marty.
Johnson.
yeah,
And then the Mala presentation from David Mister.
got that, yes. Okay, thank you.
where do I have a copy of the proposed? I guess here it is. That's it, right there. Okay. In the essence of time, I don't know whether it's necessary that we have this on record or not, but for us, Mr. Johnson, would you state your name and address and blah, blah, this for the record, and Pete, you next, and Mr., and so on and so forth, just for my edification, in case I call you by the wrong name.
My name is Martin Johnson, Martin Johnsson, address 9869 Diversified Lane, Ellicott City, Maryland, 21042.
My name is Pete Samios, 152 East Main Street, Westminster.
Good morning, Mr. Chairman, members of the board. David F. Mister for the law firm of Mr. Winter and Bartlett. My address is Suite 404, 30 East Padonia Road, Timonium, Maryland, 21093.
Good morning, Kelly Schaefer Miller, 73 East Main Street, Westminster, Maryland, 21157.
Gwen Asbury. I work for the Carroll County Arts Council at 91 West Main Street, Westminster, Maryland, 21157.
And Gwen is just here with me for the one limited discussion related to the Carroll County Arts Council licensing.
I'm sorry, I missed your name.
Oh, Gwen Asbury.
Gwen, what is it?
Gwen Asbury, Asbury.
Thank you.
I missed it too, so thank you. I assume the simplest way, you all have a copy of the previous wording and the new wording and so on and so forth as exist in this wonderful booklet. And the changes are marked and so on and so forth. So I'm just going to briefly go through these things. We'll go through them where we have, as a board, suggested changes and so forth. And if any of you have any suggestions, particularly grammatical or spelling or anything, please don't hesitate to remind us. My colleagues here have degrees from other institutions, but I attended the University of Maryland back when academics, at that time, classes include running up and down the steps at the university and tap dancing and stuff like that, so my English might not be correct. But we have the illustrious attorney, Mr. Dixon, up here to keep us straight. The first change that, and I'm not going to belate these things that we have, is on page 2. And I'm going from this, so it may not follow the exact pages as listed in the book. There's simply a change of a word, adding Treasury Alcohol and Tobacco Tax Commission and the phone number of the building at Goldstein Building. And of course, the next rules and regulations were revised and adopted September. Well, that date's got to be changed when we officially do it. And Rule 2B, B. The notice shall include references to the board's power to summon witnesses. That was taken out, but now I understand it's back in. Am I correct, Mr. Dixon?
I think so.
Wait a minute, I'm looking at something different than you.
No, I'm on the first page here now.
Yeah, but
You ain't even got the right one.
this is what I was just handed to us.
Look at the one that came in your packet.
What'd you change?
We got rid of that line in the packet.
Why didn't you tell me? Shame on you. No grapes for you. Yeah, you did. If you even changed the 1st of October from September.
Yep.
Okay, but however, under Rule 6, in the bottom right-hand corner, outdoor seating, a drawing depicting outdoor seating is required. Turn over on the next page, under the right-hand side, Rule 6, 2A, been changed that at least one of whom shall be a registered voter and taxpayer is no longer applicable. However, the word resident of Carroll County has been added, resident of Carroll County when the application is filed, and shall have resided in Carroll County at least 2 years prior to the application has been struck. further down, a registered voter and taxpayer resident of Carroll County. Well, a registered voter and taxpayer is struck from the item. And the next sentence down, the application is filed and shall reside in Carroll County during the entire tenure as resident licensee. Shall have resided in Carroll County at least 2 years prior to application is struck. Okay, on the next page, on the right-hand side, under Rule 6.2B, registered voter and taxpayer is struck as previously, and 2-year residency is struck, and the residency, or registered voter and taxpayer has been struck to conform with the prior. Under the next page, at the bottom of the page, and this is where I have a question, the very last words on the left, pecuniarily, I thought we changed that to financial other places.
We did. I think we changed it. Every place we saw that word, which I
changed
will
it.
not
We
utter.
changed it.
Oh, we changed.
Just let me butcher it, but you didn't bother correcting me. So that will be changed to financial, correct?
Yes.
So you might want to make that change if.
And where's that? Because on mine it is changed.
It is changed on the right hand.
No, it's on the bottom
Over
on the
here?
left.
Okay, so this is
That's
the
the
old.
original.
This is the old stuff, this is the new stuff.
On the right is the changed
Yes,
portion.
so we did,
We did change it
Joe
over
did
there,
do
but
it.
up at the top,
uh,
says entire tenure as resident licensee.
yeah, that's the previous rule.
Right, on the other
previous
page.
page, yeah.
And we changed, as you mentioned.
Yep.
How do you pronounce that, Miss Kelly?
Pecuniarily.
I was gonna ask Keith, but I wouldn't understand what he said. All right. It looks like on the next page after what we just discussed, that's the only thing that's been changed from that word to financial interest. The next page under the right-hand top, Rule 10D. However, after has been struck in the word before. A prospective transferee may work for salary only under the existing licensees for a period to be determined by the board has been added, provided that the board approves the arrangement in advance. Under 15B, renewals. A little background on this. People wait till the last minute to do a lot of things. And this past year probably was a little bit unusual, but not totally unusual, where people wait until the very last minute to come in, and there's a hold placed on the license by another commission or tax office or someone else. And it may have been cleared up, but our office has not received notification that it is clear, and Joe has to do some last-minute heavy work to be able to issue those licenses. So in order to kind of prevent that, the board recommends that the statement, all state and local taxes must be paid by April 20th of the renewal year, or a fine of $50 per day will be incurred until the tax payments are satisfied. And if you question where the $50 come from, that conforms with late payment of, or late renewal of taxes and so on and so forth. That was the intent of this. Okay, the next page, top of the page. Shall result in revocation has been struck and the word suspension of the license till the establishment is temporarily closed in accordance with the rule, with Rule 11, and result in revocation hearing to be held at the next liquor board's hearing date. as you all know, revocation is much more serious than a suspension and creates a lot more work for not only the licensee, but our staff as well. Corporations, Rule 16, the next one, multiple places. That word has been changed. Moving on to the next page. As we go through this now, I hope you understood what I said, and nobody said anything. If there's any comments or suggestions to any of these things as we go through, I think that's the time I prefer to discuss it rather than jumping around at the end and back and forth and so on and so forth. Yes, sir.
Mr. Chairman, I'm sorry I misunderstood you. I thought you only wanted clerical corrections as we went through, as opposed to substantive, because everything I would testify about today would be substantive. If you want to hear from me about earlier
Do you want to
provisions.
go back? Yeah, let's go back.
Okay.
Let's do it so that when we get to the last page, we've had recommendations and suggestions and so on and so forth and discussed it.
Well, then I would draw the board and everyone's attention to the second page of the proposed rule changes, Rule 6.2A. And of course, this would also carry over to 6.2B, but I understand, obviously, the board's intention, and I think that it's congruent with the decision in the Tennessee Retailers case from the Supreme Court back in 2019, maybe not 2019, and that you've done away with durational residency requirements. And I applaud you for that. I think that's pretty clear that Supreme Court opined, very clearly held, durational residency requirements are not constitutional. But I would urge you to also expand the rule change and to do away with local residency requirement, even though there's no durational component, and go to a residency in the state of Maryland for the local residents. One of the things I had sent to the board ahead of time was an outline that I did of a presentation I was asked to give to the Maryland Association of Liquor Administrators back in May. And the springboard, of course, is the Tennessee Retailers case. And, Mr. Dixon will tell you, all lawyers will tell you, holdings are what really count, but we can get an idea where the courts are going by other things they say, which would be called under the law of dicta, probably. The holding in that case was just about durational residency requirements, but they talked about some other things. However, I also provided an opinion of the Attorney General of Maryland to the Harford County Board of Liquor Control Board, your sister board in Harford County. And in that, the Attorney General clearly opined that not only would durational residency requirements be unconstitutional, but in the Attorney General's opinion, any local residency requirement in the local county or Baltimore City or Annapolis City, each ones have their own board, in their opinion would also be unconstitutional. That to serve the purposes of appropriate control of alcoholic beverages, that it is sufficient to require essentially a resident agent, like for a corporation or a limited liability company, or a limited partnership in the state of Maryland, and that would be a Maryland resident to do that. And I would urge that on the board. I know there's some feeling out there that boards cannot probably just change their rules the way they would like to do it, that particularly where there has been historically a statutory requirement applicable to that county. However, I believe that in a situation where there may be a clear holding of unconstitutionality, that it would be appropriate to do that and do it by policy and practice then, if they're willing to do that, until a legislative change can be made. The reality of life is, even if the General Assembly says something's law, if it's not constitutional, it shouldn't be enforced. I would urge you to look at some of the other boards around the state. There has been for a period of time an effort on the part of various counties to do away with the local residency requirement. We did it in Baltimore County back in 2012, did it by legislation. Prince George's, Montgomery County have all done that. Harford County has done it by policy and practice as a result of that Attorney General's opinion that I cited and provided to you. I don't know that I think in the last session they did achieve that through legislation. If for some reason the board doesn't take my recommendation, I would certainly urge you to recommend to your local delegation in the General Assembly to make that legislative change. I'm going to work with my retailers associations in Baltimore County and the state, Maryland State Licensed Beverage Association, to try and get an across-the-board change, if we can get support for that down to the General Assembly. Sometimes that's hard to do because the local delegations sometimes just don't want to go that way. But I would suggest that you can do this because the law is pretty clear, and even though it may not be compliant with the existing statute applicable in Carroll County, I think it is the correct thing to do under the law, because you won't be able to get that legislative change until at least next June, I would say, would probably be the earliest, unless it's considered emergency legislation. That's all I have to say about the residency requirement, unless if anybody has questions, I'd be happy to respond.
Mr. I have a question. In Tennessee Wine, was the court precluded from considering the residency requirement along with the duration requirement?
Interesting question. I find, and I don't claim to be a constitutional scholar. Certainly looked at a number of things, argued constitutionality back in my days as a prosecutor and since I've been in private practice. You know, the Supreme Court always takes up an issue, and it's to them, it's discretion. They never are compelled to, except in disputes between states and a few other original jurisdiction matters. In that case, I think they took maybe the path of least resistance, that durational residency requirement that they had in Tennessee was so onerous, so ridiculous. If you looked at the case, the most ridiculous thing was you could have a qualifying resident licensee when you applied for the license if they had been there for 2 years. But then to renew that same license, they had to be a 10-year resident. I mean, I don't even know how they got there, but strange things happen sometimes in politics and legislation. I think they did discuss in dicta, not the holding of the case, that just about any kind of mandatory residency requirement would likely be unconstitutional if the right case came up. I mean, I think their argument was to say, how much more effective is it to have somebody who resides perhaps at the far end of the state of Tennessee as opposed to somebody who just resides across the Kentucky-Tennessee line, something like that.
I remember that.
And I would suggest the same thing applies here. Is it more likely that someone that resides in the far, on the Carroll County, Pennsylvania line is going to be more compliant with the state law applicable in Carroll County, your rules and regulations, than someone who just lives over in Randallstown, just on the other side of the Carroll County, Baltimore County line? I don't think so. I don't think there's any real supportable legal argument that would be true.
So the Maryland legislature could have considered residency along with the durational when they changed the law in 2020.
Yes.
They could have gone beyond Tennessee Wine if they wanted to.
And many of the counties, through the local delegations to the General Assembly, have prior to Tennessee Wine. Like I said, 2012, Baltimore County. I don't remember exactly what year it was. Montgomery and Prince George's went that way. Howard County introduced a bill this past session, but it was politics. Nobody had any objection to the substance of the bill. They are upset because it got introduced at the 11th hour, and it got ruffled some feathers, so they forced them to withdraw it. I wish I could tell you that I really had great insight as to what motivates sometimes the local delegations on things. Sometimes it's constituent input. I think, and I'll leave it up to people like Pete who can speak for the retailers, but I don't think by and large, my clients, and I represent Baltimore County Licensed Beverage Association, have since the mid-'80s, very large retailer association. We supported the change in 2012 in Baltimore County. And I find that, I think most of the retailers think that, Maryland's good enough. I honestly think that the very local residency requirement sometimes creates some mischief and some, misrepresentations. And I hate to see that, because then that means people potentially get in trouble later.
Yeah, right. Well, I agree with that last statement for sure. Thank you.
Pete?
Well, I usually agree with Mr. David, but this is a little bit different. I think we should wait for the legislature to make a change. I think it's a pretty major change. Liquor business is funny. Sometimes the smallest changes cause big changes in the marketplace. I don't think it's a small change. I think it's a big change. We have 24 subdivisions, 24 plus liquor boards, and there's local control. And I think there's reasons, and good reasons for that. So I'm not necessarily against it, but I think it should be done in the proper manner through the legislature, whether it's statewide or county by county. And probably a good shot that it will be done this year, but I'm not for local boards changing major piece of legislation, even though they may have the power to do it. I think you got to follow. I think you should follow whatever the law is. That's the precedent that should be. And if we want to change it, we should ask our delegation to change it, or the state assembly to change it.
So, Pete, what do you think about how we apply that law in practice?
Yep.
Our resident agents, do you see any problem with their participation in the license that
It's
they are
not
resident agent
perfect.
on?
It's not perfect, and you guys see it all the time. But like I say, they still have to bring somebody in that's local. I'm resident agent for Buffalo Wild Wings, as you know.
And you think that's a good idea?
I think it's good that you have somebody local. Now, I don't think that most resident agents, they just do it to have their name out there. But I go out to Buffalo Wild Wings all the time. I observe what's going on, because I think that's my job to do that.
You're in the minority, though. That's
Very much so.
That's
Well,
probably
I also know a lot about the business.
what the resident agent should be doing, but
Yeah,
you are in the minority.
but again, I think it goes back to, it needs to be done by this legislature. That's my own personal opinion.
The only comment I would say to that is, if there was the right case, and I'm a very pragmatic guy when it comes to an attorney representing my clients, I don't like to do things and incur the expense for them or put them at risk, maybe having a license application denied or something with their license. But I think this is ripe. If the right case comes along in Carroll County, and somebody says, we don't think this is right, constitutional, they refuse to have a Carroll County resident license, you deny it, appeal to the circuit court, I don't think it's going to hold. I think the circuit court's going to rule, that's unconstitutional, you can't enforce it. That's just my opinion. But I don't think you can have much more persuasive authority than the Supreme Court of the United States and the Attorney General of Maryland.
So some of these establishments, when they need a resident for the license, some of them just get a customer that's been coming in over the few years. So it would be a major advantage for them if it opened up statewide for them to be able to find a licensee. I
think what you would most likely have is someone who's actually involved in the operation then. Someone who probably is not a technical owner, but a real owner, operator.
That's a good point you brought up, because the other way around, they're just picking somebody that, the only reason they're picking them is because they're a resident of the county.
Well, my comment to that be is, they could put somebody in the business on the license. They don't have to be the resident agent. They're still on the license. They're still responsible. If they're with the company, and they can do that. But the ideal of the resident agent, from what I would remember, is you have somebody local that the board can go to if there's a problem. Some of these corporations, Buffalo Wild Wings, I mean, you try and get somebody in authority to return a call there, it's almost impossible. Now, maybe if the liquor board called them,
So to play devil's advocate, so you're saying that if they're local, we have someone that we can call in here. Well, even if they live in the state, we could still call them in here.
Well, I think it's a little easier, yeah. I mean, the idea started, first of all, with just being Carroll County. Obviously, that's out, I think, and I agree with it. I think the recommendations you made are compliant with current law and current judicial opinions. I don't know if Carroll County needs to be the one to change it. You know, it's just.
Well, we have other counties changing it right now.
Yeah, well.
Speaking to your point, Mr. Harmony, that's the whole purpose under Maryland law why you have individual licensees for these limited liability entities. In some states, like Virginia, they have corporate licensure. They don't even have that individual responsibility. But Maryland, and it probably is a wise decision, has always required there be individuals to be there. So you can bring a physical human being in front of you and sanction them. And of course, you know, in my opinion, the biggest sanction is going to be you have the authority to do something to their license. You can put them out of business. I think that's a much stronger inducement than having somebody reside in Westminster or
In the county.
you know.
So if I understand your argument, Mr. Mister, you agree that the Maryland legislature has retained, under the 2020 enactment, they've retained the resident requirement, did away with the durational requirement, but you feel that even though perhaps we are restricted from being more open than state requirements, the fact that this is likely to be ruled unconstitutional releases us from worrying about ignoring the state law, which we would be doing. Because the state law, I think, is pretty clear that in many instances, there has to be a resident of the jurisdiction, of the licensing jurisdiction. Do you disagree with that?
No, I agree that you are, in my opinion, you are released. If a statute's unconstitutional, it's not,
Right.
it shouldn't be
So your
enforced.
opinion is the new enactment of 2020 from Annapolis, there are unconstitutional provisions regarding residency requirement.
What they did is they did so broadly, they indicated the jurisdiction, locality, you know, they left it kind of open, said you kind of pick what you want to do, and I don't know whether that was a compromise or not.
Yeah. Well, sometimes they mention state.
Yeah, yes.
And other times they say jurisdiction
Yes,
or
yes.
municipality.
Yep, exactly.
So
So they clearly.
chose their words.
Yes,
Yeah.
no question. What I think is, if the board's concern is we may be doing something illegal if we approve somebody just to be a Maryland resident in Carroll County, I would say, who's going to complain about that? Maybe a competitor. Let them take the burden of taking the appeal on that. Let them pay the cost, because they're going to lose on that and do that, rather than deny the applicant under those circumstances.
Pete, would you challenge us if we did that?
Oh, I don't know if we challenge it. You know, it'd cost a lot of money, but.
Yeah, well, that's the point.
It's not that we're against it, it's just that I think, I'll go back, I think it's the legislature's job. You know, that they're there for a reason, you know, you guys are there for a reason.
And they
Their
just-
job is to create law, you know,
They just visited this issue.
yeah.
But Mr. Mister is making a good point that if it's
Yeah.
constitutional, it doesn't matter if they just visited.
Well, but right now, it's constitutional. You know, we're talking about now.
No, I
If,
agree.
if a case is taken and somebody changes, a court overturns it, then we'll follow the law.
Right.
But right now, this is compliant.
Right now, it's presumed to be constitutional until it's not.
Until otherwise, absolutely.
But compliant and unconstitutional are two different things.
I'm sorry?
Compliant and unconstitutional are two different things.
Oh, absolutely, but it's not unconstitutional now.
Well, that's not what the Attorney General says.
Well, Attorney General's,
Well,
his
officers,
opinion's
yeah.
worth as much as my opinion. I'm sorry. Attorney General's
I
opinions
don't
are
think
worth.
lawyers would agree with you on that.
Well,
His pay is probably different.
I don't know. I'm not a
You might
lawyer.
want to ask Mr. Frosch what he thinks about that.
Well, I don't think much of Mr. Frosch either.
He's retired.
If I could say something, I would just say I'm in agreement with Mr. Mister. And the point is, we don't know who could come, anyone from Pennsylvania could come in here, somebody from Littlestown. It may not be Pete's organization, but it could be someone from Littlestown, somewhere, you know. And they push us to, we know they come in here for a license, and we're gonna say, if we deny the license, they'll be right at the Carroll County Circuit Court, and they're gonna overturn it, and they're gonna get a license then. So we can do it one way or the other.
They're coming in
We
from
can
out
wait for somebody that we don't even know or
of,
don't
they're out of state,
anticipate.
they're not gonna get a license.
They're
from
out
us.
of state. You said Pennsylvania.
Right.
State of Maryland.
But based on what Mr. Mister said in the Tennessee case, Littlestown is much closer than Garrett County and Eastern Shore. So
But it's not
they
in-
could put that whole issue into play, that we're closer, we know Carroll County rules, we're there all the time.
There's
know
no
what?
question, I don't disagree with Mr. Dixon. There might be ripe for that in the future. Somebody may try it. There are, look, I'm telling you, you got people like Total Wine out there and stuff like that that constantly challenge. I've looked at a lot of these appellate decisions of federal circuits around the country. Total Wine's probably in half those cases. It was Total Wine was this Tennessee case. It was one of their subsidiaries. They've got, how many, 1,000 liquor stores?
200, a little over 200.
200, I exaggerate. Okay, so only 200 liquor stores.
Only 200.
Yeah.
And, of course, one of their owners, principal owners, is a United States congressman here in Maryland. So I don't know what'll happen in that regard. I also can see where it could evolve where merely a resident agent, like for a corporation or LLC, I must be the resident agent for probably 50 companies, and I don't have one bit of financial interest in them. I get paid some legal fees occasionally by them, but I don't have any ownership interest.
Well,
I
You're a
can see-
resident agent just to receive service.
Right.
So that's different than what we're talking about.
I understand, but I can see that that's a potential issue also. When you have, if you have individual responsibility but only have resident agent to be served, I don't know. I only say that in support of Mr. Dixon. There's always enterprising people out there. I've never found it practical for my clients to challenge something unless it's, really causing them harm, but the case is going to come along, in my opinion.
I still think the issue with the problem with the county resident licensee is the fact that most of those resident licensees that are picked are only picked because they need someone that lives in this county, and it's usually a customer, and they have no idea about alcohol laws.
My 89-year-old sister has recently been a resident licensee in Baltimore County for a developer. They have something called a developer's license in Baltimore County, where a landlord, property owner can purchase a license to retain it till they get a tenant. And the reason that's important in Baltimore County is that, as with some of your licenses here, your A licenses say, there's a limitation on how many licenses can be issued. She doesn't have anything to do with that at all.
Right.
She's just the resident. My paralegals have been resident licensees, and they have whatever the minimum pecuniary or now financial interest that's required. But it seems to me that it's an illusion.
It is.
And I don't mean to jump ahead, but in that regard, I would be so bold as to make another substantive suggestion to you. You have the threshold ownership for your resident at 10% or $5,000. And I also think that's just probably doesn't make sense anymore. I think any financial interest should be enough for the resident licensee. It's not going to give them any more responsibility, any more control. And for that matter, in a business these days, $5,000 is nothing as a startup cost. It probably wouldn't even come close to representing 10% of an investment in a business.
And we see that every time.
Yeah.
And there's always a question of how legitimate that $5,000
And,
is.
that's what always bothers me too, because people, they're not really trying to perjure themselves. But, you know, they need to get the license, so they do that, but I think it's just a recipe for disaster. It's mischief. And I always am worried about that. You know, I have to accept what my clients tell me, but I don't know whether that money ever changes hands.
Right, I agree with you.
We don't either.
Well, if we're going to do that, then we just get rid of the resident licensee, you know, that's where you're heading. So, your job is to decide whether you want to have some local control. I mean, that's what I always go back to. And I'm sure that's what the legislature is going to debate, you know, local control. I just see it, if you get rid of all that, then you're going to have these big corporations come in and, you know,
What's Buffalo Wild Wings?
a big corporation.
Okay.
I just said, look, their structure is like most everybody else's. They got this layered structure, general managers and district managers and store managers, you know. But you know, they're in Atlanta, and the girl I deal with is in Minnesota. You know, so what do they know about Carroll County? I don't know. Maybe I'm old fashioned. You know, look, if the legislature changes it, I'll live with it. If they don't change it, you know, I don't think it's up to you to change it. That's just my opinion.
Have we discussed residency enough to move on?
I have one comment about.
Chairman?
I'm sorry, go ahead. No, Bruce, no, it's a different issue. It's a different issue.
Just don't say the same thing. In the essence of time, don't say the same thing.
No, definitely not. No, just on background, when I found out that this resident agent law was changed a couple of years ago, I dug into it as much as I could, and I came to the understanding that 2 non-government organizations hired a lobbyist in Annapolis to get this pushed through, and that lobbyist went to Delegate Dumais of Montgomery County, and it kind of sailed through. I took some kind of inventory of liquor boards around the state and asked liquor board members and administrators who actually among us, not that I'm having been a part of the liquor licensing system, but who among you asked for this? And everyone, I can't say every liquor board, but the liquor boards who were listening to me and answering me, they said, number one, we didn't ask for this. Number two, we didn't even know this happened. Marty, you're bringing it to our attention. We didn't know this law had passed.
I'm sorry, hey,
Yeah.
which law are you talking about, the 2020 enactment?
I'm talking about the
Resident?
where the resident agent is now required. Registered voter was dropped. Resident agent was
Right, and that was in response to Tennessee wine, and that
Correct.
was in the legislature and passed in 2020. That's what we're talking about?
correct. That's right, and it was initiated by Delegate Dumais in Montgomery County.
Where's Congressman Trone from?
He is from Western Maryland, and he's got a little piece of Montgomery County.
That's his
Just wraps around his house?
He lives in Potomac.
Yeah, he lives in
My
Montgomery County.
comment was, I should have said, where does he reside?
Montgomery County.
And the Montgomery County delegate introduced the bill?
Yes. Yes, Delegate Dumais, D-U-M-A-I-S. So anyway, I just want to give you that on background so that you've got an idea of where this actually came from. And it was written, part of the writing that was put into Annapolis initially was, we are reacting to the Tennessee case. And as a result of that, Delegate Dumais wrote, I suggest we do this. And then it sailed through. Perfectly fine, laws happen that way all the time, but that's the background. Very specifically, alluding to just a little bit of what Mr. Mister said, just an FYI, he mentioned Montgomery County and what they do. Well, Montgomery County said, we will obey the law, but we see this one word in there called jurisdiction. And we think that because this is a license issued not by the state but by the counties on behalf of the state, jurisdiction means Maryland. And so Montgomery County will accept a license issuance with a resident agent as long as the person lives in Maryland. They still have a buy-in as far as you have to be part of the company. Now, Prince George's County, just second and final example of this, Prince George's County just says, if nobody who is an actual owner applicant here happens to live in Prince George's County or lives in Maryland, all you have to do is name somebody an adult, an 18-year-old or older, who consents to receiving paperwork and receiving phone calls on behalf of your company. They do not have to be part of the company. They don't have to buy in. No $5,000. No 10%. Baltimore
What county
City.
was that?
That's Prince George's County. Right. That's Prince George's County. So I just want to fill in a couple of the parts there. I'm a law and order guy. You know that. Law enforcement for 38 years total, and I was the inspector in Howard County for 13. I can tell you that to the board, I put a whole lot of violations in. I never once, and this is just my experience, I never once had to go directly to the resident agent because I couldn't get somebody who was part of the company. And of course, we dealt with, I wrote up, big corporations, Fuddruckers. But I just never had a problem getting them. I never had to, as I said back then, when I was asked about resident agents, I said, I need to be able to reach out and touch someone, like the phone company commercial says. But I never had a problem with that. One exception, I couldn't get a hold of one owner because she had lied on everything, and she actually lived on another continent. She lived in Korea. So that license was revoked. But anyway, so that's the jurisdiction part. That's all I can offer to you.
I'd like to make one comment on that. Montgomery County says the jurisdiction is the state, but any of those licenses are only good in Montgomery County. It ends at the county line. They don't have statewide privileges. So you're given two different definitions.
Yeah, there's grammatical juggling here, gymnastics, no doubt.
Sure. Last
Okay,
thing.
let's move on to the next item.
Can I, I'm sorry, are you done, Bruce?
Just, if I may add one last thing on the resident agent rentals. I'm going to call it a rental program. It's rent a resident when you don't have somebody who's qualified to be a resident agent. If you're looking at a little mom and pop place, most resident agents, they don't do it for free or for friendship. They do it for money. So you're adding, not you, but added to the situation is, you know what, I got to pay this guy $1,000 or $2,000 or $2,500 a year on top of all of my other expenses. And if you're trying to start out a business, you're a small person, you're not a big corporation, you got another $1,000 to $2,500. I think the most I ever heard was $2,750 a year to rent a resident agent who couldn't care less, as it turned out. Thanks for listening.
Okay, let's move on.
I have a couple other things. I think you'll be happy to know that there are probably more observations or things to bring up rather than, tussles.
We've
like-
already discussed.
No, nothing we discussed before.
No, I mean the items.
Oh, yes, there are things that you have mentioned, and I would go to page, it's, which page is it? It is page 1, 2, 3, 4, the 5th page, where you, in section 2, talking about financial interest, the issue about, with landlords and leases. The only observation or concern that I have, I have practiced in every jurisdiction in Maryland, but like 4 counties, I think, or 3. And I represent a lot of landlords with regard to alcoholic beverage licensing matters, particularly where they're interested in getting licenses for their shopping centers, et cetera. The only question I have is that I'm not sure, and I don't know whether the board looks at this a lot, but this idea of the greater than 3% of gross sales where a percentage rent is charged. I have some.
We do look at it. Yeah, we do.
I have some concern about how legal that is also, and whether or not that that really gives them some sort of ownership or control. If it's strictly a rent issue, I think that certainly could be challenged by a landlord where they have no other control factors other than matters under the lease, and they have no ownership, et cetera. I don't think I've ever really come across that before here or anyplace else where that's come up and where someone's been challenged on that. I don't know that it's regularly a problem. And what the genesis of that rule was here in Carroll County at the time, I'm sure the idea was not to have a disguised ownership where effectively they were trying to hide their ownership and do it by getting it in the form of what would appear to be rent, and it really wasn't rent, it was profits. That's the only question I have. I don't have any problem with having people honestly disclose any control or ownership interest. The only question I have is whether that interferes with contractual relations between a landlord and a tenant, and I'm not sure where the 3% came from, that magic number. That's the only thing I observed. And if there are any questions on that, then I would just make the observation, and I hope this doesn't come back to bite me. You know, if people haven't paid their taxes on time, that interferes with the renewal of their license. And the license would, by operation of law, expire. And that may be a lot easier issue for the board on judicial review than revocation. Because if you come in for a revocation hearing, obviously you go through the whole with that, where it might have just happened on its own. If they didn't pay their taxes and the controller wouldn't let you renew the license, it would expire.
Is that state law? In the
Yeah.
tax code, or?
I believe that there, I will have to look and give you the specific section number of the Alcoholic Beverages Code, but I believe there is a requirement that any license be held if taxes are not fully paid.
But you said expired, so I'm just wondering if it's in the tax code or the Alcoholic Beverage Code.
No, I think it's the Alcoholic Beverages Code, but I should be able to cite you on that. In other words, there's certain prerequisites to the annual renewal of licenses. And if you can't renew the license because the taxes are unpaid, then doesn't it expire? Because all licenses are annual.
Yeah, but are we talking about fees to the board as opposed to taxes?
Fees to the board were like $50 per
Yeah,
day.
so I think the revocation suspension language was more in line with a renewing application, or did we also cover whether they paid their taxes or not?
Well,
Yes.
I'm not sure exactly if I'm answering your question, but I get state holds and county holds. And this year, we had people run up to the last day before they paid, and I could not get my releases in time. Our wording said that in that matter, the license was revoked.
In
And
our rule,
in our
which we've
rule.
changed to suspend, or we're talking about changing to
Yeah.
suspension. But you got a hold from the state regarding what Mr. Mister's talking
Regarding
about.
taxes, yes.
Okay.
So maybe it's belt and suspenders. I'm not telling you should make this rule change, and I think suspension is a much fairer thing than an automatic revocation. But you may not even have to go to that second step once they've satisfied the stuff and have that revocation hearing. Or you may not want to.
Yeah, but
Changes
if
I
that,
think we got there because this year there were like five licensees that hadn't, and we knew it was gonna be automatic, and our next meeting was like 10 days later, so they would have been revoked for 10 days so I think that was the whole purpose of saying it's suspended, and then
Right.
revocation hearing at the next meeting we would hold.
Yeah, because if they were revoked,
yeah.
they couldn't get a license again, and
Right.
even that establishment couldn't
Could
get
not get a
anything for
license.
6 months, per the state law.
Yeah, your revocation is way too onerous unless it's absolutely necessary.
So if they're expired, do they have to start a whole new licensing process?
I think so.
I would think so.
I would think so, yeah.
If they're if they
So
expire.
it's something you ought to put some thought into.
But
I
we-
agree with Dave. I mean, if the license is over, it's over, it's expired.
But if it's expired, at least they can get it again.
That's true, they're not
They can
prohibited.
get it, right, I don't think revoke should be in there for that.
You don't either. That's why
Either
we changed it to
suspend, I
suspension.
agree with him. I think expired is the word you should work around.
I don't think that was his point. His point was that they're automatic according to tax law. Okay, moving on to the next page then is where we stopped. And I guess that's at where, what'd you say that word was, Miss Kelly?
Pecuniarily. By the end of the day, I won't be able to say it, though, so
Your tongue is going to hurt.
you only have so many times to ask me that question.
Okay, on the next page at the top, the 2-year residency is out of there. And the word has been changed again, all the way down to the bottom, and the registered voter and taxpayer is deleted. However, resident of Carroll County at the time has been added, and that's, we've already discussed that. Under restaurant, the top of the next page, filing of an application and shall reside in Carroll County during the entire tenure as resident licensee.
That's the previous rule.
It's in black.
Yeah, so I think you're here, not there.
Oh, yeah, okay. So there's no change, basically, other than that. Be nice if these pages were numbered at the bottom. However. I guess we're up, Rule 22, hours of operation.
Well, hold on, you skipped Rule 20A, the counters.
The counters, that's capitalized. That's the only,
Well,
right?
that's just a word counters put in there.
Yeah, that's the only thing in that rule, right?
I don't change anything.
That's it, just count
And
it.
then, if you go to the second page, right, it's the seating, we're talking about,
You mean the next page?
yes.
Next page,
The next page is hours of operation.
Yeah.
right.
But you do have
Well,
1 AM, 1 AM.
Footnotes on the next page. Footnote,
So the footnote
one,
is slide in the count.
Yeah, but what's the footnote?
It's
that's on the very last page,
number 2,
at the bottom.
footnote 1.
See footnote at the top.
Yeah, where we've proposed legislations for the 50-seat requirement, and I've got some reservations about some of that, so that will be discussed as a state change for the legislators. The hours have been changed to 2 AM, which is there. And at the top of the next page, it's changed for Sunday and 1 AM on Sundays. And under Rule 24, licensees must have all patrons and non-employees removed from their premises, and in addition, blah, blah, blah. And down at the bottom, you're not only getting the patrons out, you're getting all the employees and so on and so forth out. And where did that come from?
That's basically, it's just 2 paragraphs that said the same thing, we're deleting one of the paragraphs.
It was redundant after we made that one change up top.
Okay, on the next page, under Rule 30D, there's no D, so delete that letter. That was simple. Even I could do that.
There's one above, Rule 28.
Yes, where it changed operator from.
Can I just comment on Rule 24? I don't know how significant it is to you, but you did change the language a little bit. Before, you mentioned non-working employees had to be out, and now it just says non-employees. So I'm not sure what a non-working employee is, but I guess be an employee that's
Somebody's
hanging
off.
around after their shift,
Yeah.
maybe. But you did you got rid of the term of non-working.
So you think that we're allowing a non-working employee to evade this requirement?
Wouldn't he be a patron at that time?
I would argue that as an
I mean,
attorney.
yeah, I just
If
want-
somebody's an employee, even though they're not working that shift, say they're day shift and they're there that evening, technically it probably wouldn't be there. I can't imagine it's going to be a real big problem for you. I mean, how occasionally would that happen? But I just want to point it out that there is a distinction.
Yeah, I agree with you. I think that
Put the word
it gives
working.
clarity to it. Yeah, just,
Add the word working.
yeah, all patrons and non-employees, comma, non-working employees, removed from, I would just add that definition.
I ran into that in Howard County on a couple of occasions, so just allow me to suggest on duty as opposed to working, if somebody decides to really argue. Because on duty means that there are records that show that you're working now and you're getting money for it and we're paying taxes on it, as opposed to, yeah, I was working.
You
that's
know,
a good
that
point.
brings up a point of a case that we had, a serious case involving a person who indicated they were not working, but they,
But he was an owner, so he doesn't keep records of his working hours.
but suppose he'd just been the manager.
And theoretically, it should be punch in, punch out.
Part of the year. Okay.
Rule 28.
Rule 28, music.
The county has changed their noise ordinance, and this goes along more with the county's noise ordinance. They got rid of dB levels, and they say basically from 10 PM to 7 AM, no loud outside music.
So they got rid of DB levels?
Yes.
Got rid of, yeah.
This rule does not say outside, though.
Yeah, I was
It
gonna.
says any music. So that means anybody who's got live music at 11 o'clock would be in violation. You must have some places up here that have later entertainment.
In a manner that disturbs the peace and quiet of the neighborhood.
I got you,
So-
I understand.
But if they allow music from inside, that just, then,
That gives the board some discretion, there's no question. I just wanted to mention that it's not strictly limited to outside. And that's probably what you want. I mean, I guess, if the music's so loud you can hear it 2 blocks away, even though it's all indoors.
For you legal students, what is a deck considered if it is partially enclosed?
I think if any portion of it's outside, you're going to be subject to whatever those standards are from the county or the city.
Because we have 1 or 2 establishments that would be applicable. Whereas an outside deck, that might be 3/4, 3 sides. Okay, nothing under 30D there until we go to the next page. And a specialty on-site consumption permit for Class 1 distilleries will be issued upon approval by the board at a cost of $500 annually. That was added in because it's not in the existing rule, and the distilleries were approved and so on and so forth after that booklet was issued.
I have a question. So where are we?
Rule 33.
Rule
D.
30F.
All right, on the page after the beginning of Rule 33, right?
Yes.
Okay, on the right side are our changes, on our left side is the original rule, but I have it here, that's a bold on the left side. So is that the original rule, or is that something we're adding on the left side?
No, that was the original rule on the left side, that's just how
It came out bold?
yeah.
Oh, okay.
But
So,
we did
The
add,
change is on the next, on the other
on the
side
right
of the
side.
page.
yeah,
yeah, okay,
Class D breweries.
yes.
okay.
Class D license for breweries will be granted regardless of population numbers as long as the brewery has obtained a Class 5 state brewery license. These licenses will be designated as Class DB, and this license will allow selling their product for both on and off premises consumption. And this is to comply with state law. Okay?
Well,
I don't know, comply with state law, but basically, we're allowing the Class Ds, the breweries would not count towards the population.
Right.
When we're separating them.
I thought that's the whole reason we put that in there. The Class Ds used to be one.
That's right.
election
That's why it's in there.
So,
why we
I
put it in.
mean, by making it 1 for 5, but what you're saying, you're gonna have unlimited distilleries and wineries, and I don't think we'll ever get to that problem, but,
I mean, if a brewery wants, I think it's good economic development, a brewery, winery, or distillery wants, well, just breweries.
Yeah, but
We don't regulate the wineries. But so if you would have, if they want to put 7 breweries in Carroll County, we're not limiting how many they could do 7 Carroll.
I
We'll
mean,
let the marketplace decide how many there are.
Yeah, I don't have a problem, I'm just saying, there's a lot, when you go 1 for 5,000, you're, in most jurisdictions where they put one, there's,
It's only like
I mean,
one or
we're just
two.
talking about Class Ds, not Class As, so.
You don't have a regulation by population of Class B licenses here, do you?
No.
Okay, down under F, Class H licenses shall be issued needed to accommodate the public, and that simply is change of a letter.
Right. Yeah.
Payment of taxes. Unfortunately, we all gotta pay taxes. That's unfortunate. All right, it looks like,
It's just a repeat of what we put in earlier under renewals.
any questions? All right, under Rule 49, only nonprofit organizations may apply for special and temporary licenses. That's been added to clarify. Display of license. We're not serving pheasant under glass. Under glass has been struck from the rule. Specialty permits must also be framed and on display, and one-day licenses must be displayed. So you can just take your license and put a thumbtack in it and tack it up to the wall. It doesn't have to be preserved from the air.
Well, because you get a frame now, and most frames are plastic now, glass. If you want to get technical,
It does say shall frame the license.
and display, because.
Conspicuously.
Display it.
Or you can go to one of them stores and get a cardboard frame and put around it.
Yeah.
Anyway, it doesn't have to be under glass. Rule 57, revocation or non-renewal. To clarify, the premises for a minimum of 30 hours and 5 days per week. Such failure to hold the premises open to the public for the minimum hours specified shall be grounds for revocation or non-renewal of license, blah, blah.
I'll speak on this briefly. I have not had the opportunity to speak with any clients to know if this actually impacts them, so I'll make that known. But I will say that this rule does apply to the Class D specialty establishments and will apply to the breweries. So I would ask that this board keep that in mind and perhaps consider or be receptive to, I guess, testimony from maybe specific operations who are unable to meet the 5-day requirement but do meet the hour requirement. I think it probably goes without saying that Class A and B will have no problem meeting the 5-day requirement, but I would imagine that there might be some of these specialty establishments that are not open 5 days a week. And I was not here for the initial conversation. I don't know what the intent of that was, but if the intent of that was not to, DQ those smaller businesses from holding a specialty license, then I would suggest that that's something that the board take into consideration.
I think when this was discussed, we had a couple occasions for Class Bs
Yes.
that were not compliant with this, and I don't think we kind of thought about the Class Ds.
I mean, we can also drop the Class D, or you can make it. I mean, I agree with Kelly. I think there are probably, can't think off the top of my head, but.
Yeah.
Well,
Several that might run to a problem.
Jerry in Union Bridge, he's only open, what, Thursday, Friday, Saturday?
Well, he is a Class BR now, so he actually expanded his hours. Pub Dog is a Class B now, so they expanded their hours, but some of the class, or the state licensed Class 5, Class D local license breweries, I would imagine, are maybe like a Thursday, Friday, Saturday, Sunday sort of business.
Yeah, but the only reason,
I'm sorry.
the reason I mentioned him is prior to him getting a BR.
Yes, prior to
He
him
was
getting,
probably only open, what, the weekends?
he may have just been 4 days. It's possible he was Wednesdays as well. I can't recall off the top of my head,
Read it,
but
but
I think a lot of them, again, without having looked at them specifically, I do think the Thursday, Friday, Saturday, Sunday sort of operation is more common amongst those types of operations.
So according to this rule, Pipe the Side in Hampstead would have to be required to be open 5 days and 30 hours.
That's the only one that I just took a quick look on their Google business hours, and
would
they
have
do.
trouble
list, specifically 4 days a week. So I just think perhaps discussing the applicability of this. If this is something that the board is interested in adopting for the other licenses, the 5-day requirements, perhaps discussing exempting the Class D holders from that requirement.
Are we conflating, I don't know, specialty permits? Aren't they issued to state, or to businesses that have a state license? We don't issue them another license, or do we? I thought we issued a specialty permit, not a specialty license.
No, that's only for the distilleries, and correct me if I'm wrong.
Breweries don't have a
here, but that's
specialty?
only for the
This
distilleries.
is actually a license.
The brewer,
License.
the state law for breweries requires that if they want to have a tap room, that they have if they hold a Class 5 state license, that they then hold a local Class D license for their tap room operation.
Okay.
And then some of them, if they hold a Class 7 state license, it requires that they hold a Class B local license for any sort of tap room, which is like flood zone, for example.
Flood zone has a what?
I know, it's very confusing. The Class D, yes, sorry, flood zone has the Class BR because they switched to a Class 7 state manufacturer's license.
Okay, so they're not part of this discussion right here. They're,
Right, they meet the 5-day requirement under their existing license, correct?
It's mainly, the Class Ds were concerned about not meeting the 5 days.
Right.
And I think the suggestion would be just to drop the Ds out of this and just,
Okay.
the problem I'm having is restaurants are only open 4 days, 3 days a week.
I would agree with you. I think we should eliminate the Ds.
Wait a minute, are you saying for Class Ds, you don't want any days of operation, that mandatory?
No, we-
Because what if somebody comes in and puts a concrete building up, gets a Class D, and has rave parties?
As what party?
That's what you're talking about.
Rave.
Remember, I told you about this Class D, how it can be used for so many purposes. So you better think about that, put some kind of limitation
We're gonna
on
need to
it.
adjust that because, like,
Well, the board has the right to make hours of operations and have them so many hours. You can still make that requirement to a Class D. You can still make that part of your decision to have, am I correct, Tim? Can they make that part of stipulation of a license?
Not if you have it in statute or regulation, no.
The board would have the authority in granting the license or a subsequent hearing for a violation as a condition of continuing the license or not suspending it. You could limit the hours of operations, absolutely. What you can't do is grant them hours greater than what the legislature's authorized. So you couldn't do it before 6 or after 2.
You guys already, linen, what used to be linens and lace tea room, juice bar now. You already made her 30 hours,
Right.
didn't they?
Yes.
Specifically for her establishment. Yeah. Oh, but you didn't say anything about 5 days.
Okay, excuse me, any other comments on 57? All right, this is a good time to take a 5-minute break. All right. According to my papers here, for this section, we're all through, unless somebody has some other comments or questions.
I want to commend the board for holding this, this public hearing, if it's even a hearing, or opportunity for comment, because my experience is a lot of boards just to go ahead and put the rule out there, publish it, and then they'll have the one public hearing where they're going to act on it. So I certainly commend you for taking the time to do this and hearing us out. And by the way, if you don't follow my recommendations, I do hope that you'll certainly strongly recommend to the Carroll County delegation for the next legislative session, or even if you do follow it, I think that they should, I think they should change the law anyway.
That should be done statewide.
If we do follow, we're really going to ask them to change the law.
Yeah. I'd make one comment on the percentage override on the leases. I think one of the reasons that concept came up is because of 7-Eleven. 7-Eleven's owners are really glorified employees, and the way they would get liquor licenses in other jurisdictions was to have a very high override on a percentage. And when I say high, I'm talking 60%, 55, 60%. So they were actually the majority partner. So remember, everything in the liquor business, one little change seems like nothing. In the end, somebody will make it big. Somebody will make it big.
I also appreciate the opportunity for comment. Thank you very much for this opportunity. And I don't know if now's the appropriate time or not, but I do have a more state law-related comment specific to the Carroll County Arts Council that I am here and prepared to discuss with the board.
The 16,
Before that,
Yes.
what were you gonna say?
I was gonna talk with Kelly's paper, but
This paper
it's 16-1312, the multiple event license.
Keith, did you distribute the red line? Is that what it is? Okay.
Well,
No, that's,
unfortunately, theirs isn't in color.
isn't, well, I printed in color because I don't work at the county, so.
You're talking about the total number of days?
Mine's in color.
She does a lot
What are you talking about?
It's not a part of the package.
First,
And I also, Kelly, I also filled in,
only printed 6.
Wait,
yours is in color, so I can.
I also filled in the amount.
Oh, okay. Well,
Yeah.
then, you can convert to
Clark says first name.
color and non-color.
But this
Makes my man brain.
This has to do with an addition
Her dad
will require state legislation.
that's
Yes.
a state request.
All right, but before we get to this one,
Yes.
okay? The request that we have, and I'd like to have some discussion about changing the number of seats to allow bar stools to count. I thought about this a little bit. There's one thing that concerns me, is I think there should be a limit on the number of bar stools that can be used to satisfy that seating requirement. I don't know if we have any bars in Carroll County, or restaurants, so-called restaurants with bars, maybe Johansson's downstairs, that's over 10 or 12 seats. But I can visualize somebody coming in and getting a Class B license and has about 10 or 12 table seats and a huge bar. And I don't think that's the intention of that license.
Mr. Chairman, may I suggest something? In some other counties, what they do is they restrict the size of the bar area in pro rata proportion to the whole restaurant, as opposed to the number of seats, where maybe you could count all the seats as being, particularly if they can dine there, but don't let them have more than, say, I don't know, 10%, 15%, 20%, whatever you think is appropriate, devoted to strictly a bar area.
That's a great suggestion.
My only suggestion in relation to that suggestion is that if that's the route that the board goes to solidify the intent, that be clear that anybody with an existing license is grandfathered in some way, so that we're not in a situation where we're trying to backtrack and anybody who comes in for a change of license or something is then being reevaluated under a standard that they didn't know was applicable to them at the time.
I think that's good too. I think we only have a few that this would affect anyway, am I correct?
I think it would really just depend on what you came up with in terms of, how you're
But I
doing
mean,
that
what
calculation.
I mean is right now, there's only one or two.
No, it's probably about 5.
That have substantial number of bar seats, is what we're saying. Yeah.
Oh, I'll have okay.
What were you talking about?
I thought you meant like.
He was talking about establishments that may be cramped right now.
we have
Oh,
like-
cramped, yeah.
The one on Main Street.
So
is-
what if we just made that, like we accepted 10 bar seats?
Still won't.
I think maybe his,
It still wouldn't?
Mr. suggestion would
Maybe
be,
Kelly's with, but doing a percentage and then grandfathering everything in.
Yeah, we'd have to
So when it comes to the
grandfather.
board,
Like a floor plan percentage.
yeah.
I'll have to check archival statutes, but I think we passed one in Baltimore County where we created a deluxe restaurant license, and they limited either the square footage or the percentage of the licensed premises for the bar area. I'll see if I can find that archival statute and send it to Mr. Dixon, and to Joe, just to give you an idea of sort of a
Okay.
format, possibly.
But I mean, flip side is, any new place that comes in front of the board, if it's a bar that's 60% of their floor space, the board can say, no, this does not fit our requirements. You have discretion as a board to,
Well, right now, our
don't have
requirements
requirements.
don't have any.
but, you know,
Are you suggesting that the the top regulation be amended at the state level, but then in the local regulations, that's where there be some additional restrictions? Is that what you're? I mean, I would also say, and I know that you all know this and are very familiar with this, but keep in mind that the restaurant license already has very great restrictions in terms of the hours and the meal requirement. So I understand the intent to maintain, a strong table presence, but also keep in mind that there are other, I mean, even if somebody per se wanted to have a floor plan with a greater bar area, it still has to comply with those strict meal requirements. So in essence, they truly still are a restaurant. But I could see.
they're in your name as a restaurant. In my estimation, they're not a restaurant, they're a bar, under the guise of a restaurant.
Well, I think that you have to look at the business model to say that, because I mean, as a foodie who goes out to eat all the time, when I go to that sort of establishment, what I'm looking for is the restaurant experience. It doesn't matter where I'm sitting. So I think
you
it just
go
depends
before
on
6
the
or 7
culture
o'clock
that
in
you're
the evening.
looking. Do I go before 6 or 7?
Say
in
you
the
go
evening?
before 6 or 7. After 7 o'clock, it becomes a bar.
I think you're underestimating me and my ability to stay up late. I mean, I know I have two small
has
children,
babysitters,
but
You see, now you're giving me a different perspective. Being a wholesome Carroll County girl from a well-respected family in Carroll County, that's what happens when you go to Owens Mills for 6
listen, I appreciate the sentiment.
but our own rules says during mealtime, that sitting requirement is required during mealtime. So mealtime for dinner is 5:30 to 9 p.m. After 9 p.m., they could take all those tables out, and we can't stop what they're doing.
Say that again?
Oh, geez, Keith, you're bringing up things like nobody ever even thought about
Yeah,
now.
you see, he does that all the time. That's why a lot of this stuff is in here. He wants to
Page
create problems, not solve them.
You guys want books?
I have about 7 of them, so I'm good, thank you.
You want one after this now?
It's 28.
No, I'm good. I have one in here, and I have a separate version printed and tabbed.
You know, at some jurisdictions, I can tell you, for instance, in Baltimore County, if you're looking at something about, quote, becoming a nightclub, they regulate that through zoning. And they determine it based upon how close are the tables together, what you do certain times of the night, kind of entertainment, et cetera, and that's how they've prevented some restaurants from turning into nightclubs, you know, after hours, et cetera.
That's an interesting.
So theoretically, after between 9 and 2 a.m., they could be anything they want to be. So,
Where are you reading that?
28.
page 28 and 29. The hours are on page 28C, and then look at the top paragraph on page 29.
Okay, I'm not a lawyer. Which must be available during, but not limited to the following hours. Must be available, but not limited to the following hours, at the bottom of 28. Number 1.
Bottom of 28, number 1.
I think what Mr. Benfer is saying is that on page 29 at the top where it says during each of the meal times listed above, there must be seating available. What he's suggesting is that if it's not at one of the meal times, theoretically, an establishment could, and again, I'm not advocating for this, I'm just attempting to clarify what Mr. Benfer is stating, but that an establishment could then move those tables because they're arguably not required to have them in that same location if it's not a mealtime.
After 9 o'clock.
My common sense question to you,
Yeah, but,
you're gonna go to the expense of moving all these tables for what purpose?
Do you want me to continue to go into my non-good Carroll County girl standards here? Well, I mean, if you were a nightclub, if you were operating a nightclub and not really a restaurant, you would move the tables and open and have a DJ there and have a dance club. I mean, I honestly cannot say that this is something I have experienced in Carroll County, okay? But I would say that that's, I believe, what Mr. Benfer is getting at is that theoretically, the way it's written, somebody could move and adjust the tables if it wasn't during one of the listed meal times that they need to qualify for the license.
And my rebuttal would go back to what Mr. Mister said. It's no longer a restaurant, it's a nightclub.
Well, I would say the same thing to you.
If
I
that's the
think
case-
that there's enough, I think you would see that during a hearing, a license hearing, if that's what's really happening here. And if not, you would see it shortly thereafter and be able to regulate it. I mean, that's just I just don't see the need to try to prevent something that we don't see we're having a problem with right now in the county. Like, if we were having this as a problem, then I could see the need to further curtail it and have some restrictions there. But unless there's something I'm missing, this is not a current concern in the county as relates to that.
Now, one other thing. If these establishments that you're speaking of barely have room for 50 seats now, where the hell are they gonna put the tables if they move?
Well, you're just really thinking
they
too
put 'em out on the
logistically
deck.
into
Yeah.
this situation, but yes, I mean, that's a good point. I think, to go back to to allowing the counter seats and the bar seats, if you want to call them that, to count, I mean, I don't disagree with some kind of limitation there, whether it's a percentage limitation or something like that, but I do think in general, opening that up only allows for increased economic development potentials in the county. I mean, you have seen over the course of just your time on this board, such a substantial change in the culture in terms of the Class D licenses. I mean, things are changing. Different types of restaurant plans are coming forth. So why have something like this that would prevent them from being able to operate in our county when we could still maintain the intent, but maybe make it a little bit more flexible for those types of business owners? I assume that there's one specifically in mind for this right now, but if you recall, there was one a year or 2 years ago, I think There was one where we talked about, where we came in and revised the seating for the just beer wine license
Yeah,
because
Car-
somebody couldn't comply with that.
Cantina, I mean, County Line Cantina, we reduced it to 20 seats, because it was 30, we reduced it to 20.
And it could, because their physical capacity at that facility, even if they were all tables, couldn't be,
Because the septic.
yeah, so, you know, there are some physical constraints on spaces like countertops, bar aside, that might prevent an establishment from having a full, I mean, I'm working with a client right now who I won't name because they haven't filed anything yet, but who could not meet the capacity requirements for the full Class B beer, wine, liquor. They're fine with that, they understand that, and they won't apply for it, but in all other regards, they are a true restaurant and they meet all of the other requirements. So if they wanted to, why shouldn't we allow them to be eligible?
Any other comments on the seating number for a bar?
I just think, I mean, the main reason I made this suggestion to this rule is I have some places that are very crowded with tables and chairs to make the seating requirements, plus the bar seating, that in case of an emergency, in case of a fire or something happens, they would have a very hard time getting out of the establishment.
How does the fire marshal approve it?
They
If that's the case? How do they have a license if the fire marshal did not approve
The
the
fire
establishment?
marshal approved over 50, it's 55 seats, but I can't see how they're gonna get people out of there.
I can't see how the fire marshal would approve it if that's the case.
Could the
He
fire
damn
marshal
well-
does it by size, does it by
I'll
square
go with
footage?
Mr. Mister on this. What the fire marshal approves in Balmer County, half the establishments in Carroll County would be closed.
We use the same, I mean, theoretically, it's the same regulation for Balmer County and for Carroll County. It's state of
Theoretically.
Maryland. It's a state of Maryland regulation.
Yeah.
The board could add to the rule if you allow the bar seating, but the bar area not to exceed X% of the licensed premises. That may be a way to avoid it becoming just a bar, not a restaurant.
I like that
And also too
solution.
congested, that would reduce the possibility of a congestion if
Right.
I like
we
that
reduce the
solution.
bar seating.
Could I go one step further and even suggest maybe there be some sort of actual, rather than calculating the bar area, because that's like, what does that include behind?
Yeah.
That you do like a seating at the bar, like how many bar seats relative to restaurant size somehow, so that it's clear, like.
It's easier to enforce what you're suggesting.
Well, and it doesn't have the opposite effect of deterring somebody from having a little bit more like behind bar area for staff for whatever, you know, business reason they want to.
Right.
That might.
So not every establishment is going to set up their bar the same way, and
Right.
some might have behind the bar
Right.
space that we would count as a limitation, and it really shouldn't be.
What?
Not the wire tape measure. I want a laser.
I kind of like Kelly's.
I do too. I do too.
Well, what you're talking about is, if you're talking about 50-seat requirement, you're talking about small places and whether the county now wants to encourage smaller restaurant bars to open. Now, that's a decision for the board and economic development and everybody else to make. But that's what you're really not talking about nightclubs here. We're talking about small, almost corner, what I call the old neighborhood bar type place that holds 50 people, 60 people, whatever, at the most. And whether you want to encourage to have those types of places. And that's above my pay grade.
Okay, we discussed that enough. Let's move on. Ms. Kelly, you could start at the top of your page.
Thank you.
Tell us what you're talking about, please.
What I have submitted here is, well, yes, let me give you background. Okay, so I represent the Carroll County Arts Council, who has come to me because, as most of you are probably familiar, the Carroll County Arts Council has what's called a multiple event entertainment license, which is a license that's allowed under state law. What you have in front of you is a copy of that state law with my proposed red line changes that I would ask the board to consider and then refer up to the delegation. The impetus for this is that the Carroll County Arts Council, I'm going to to make the assumption that most of you are pretty intimately familiar with the operations of the Carroll County Arts Council, but I do have Gwen here with me who may be able to answer some specific questions if there are any specific questions about events and whatnot. But the Carroll County Arts Council for many years has operated under this license. As you'll see in here, there's a special carve-out specific to the Arts Council on West Main Street. And they have more than the 40 events per year in excess, in which they come in for per diem licenses, which is, again, specifically carved out in here that allows them to do that. What we would like to do is try to make this process a little bit more effective for them. I think, I speak for the county, although maybe I'm wrong in thinking that we want to encourage the Carroll County Arts Council. We want to support them, and they've been a great asset to the community and not a cause for concern in this regard. So my suggestion in talking to Keith and talking to Joe and kind of like trying to figure out all of these moving parts here is that one of the most effective ways to do this would be to actually request a change at the state level to allow for an excess of the 40 events per year and come up with a license fee amount for that. Now, I believe, I'm not sure what Joe put in there as a suggestion, but I think we were looking at the full Class C license fees.
Comparing them to a club.
Right.
So it's $12.50.
$12.50 for a full club license. We are not opposed to anything that's reasonable in there. The goal here would be to allow the Arts Council to have more than the 40 events per year and not curtail them there, and also hopefully make their process with obtaining this license every year with you a little bit more streamlined as well. If you are concerned at all about recommending this with it being open to, I think right now, the way the license reads is that it's open to what does it say? Fire departments as well, then we would certainly be receptive to, at that red line, also just tacking on, for an arts center, like as it's written in the rest, so that this would only the arts center would be eligible to obtain greater than the 40 events per year. That's the impetus. Like I said, happy to answer any questions. There might be some other ways that they could potentially get licensed for these events, but this is certainly the most efficient and makes the most sense and clearly was, intended for their purpose.
Are there any other organizations that you can think of that might be similar to the Arts Council on some other location or something like that?
I am unaware of anyone in our county. Again, doesn't mean they don't exist. I'm unaware of any other nonprofit who has this level of events and or who would be otherwise be eligible under this license, because this license is incredibly limited to just the fire department or an arts center on West Main Street in Westminster.
What I'm getting at, and this wouldn't be applicable, but it's probably a bad comparison, but any organization, that day-to-day, like the Boys and Girls Club, not a Boys and Girls Club, but some organization that's open 365 days a year or whatever.
That might.
Can't think of anybody. In other words.
You mean that otherwise might want to have
that
something
might-
like this?
Some other I have no idea what it would be. I can't think of any, but since we need.
If you go by one-day licenses we issue, probably McDaniel College is probably the second highest number of one-day licenses.
I was gonna say, I'm sure there might be some who might, for the 10 or
Yes, that's
20
answered.
events, per year. There's no one that jumps to mind, but that doesn't mean they're not out there in the county.
Because we discussed this before, you and I.
But the state law is extremely specific. It doesn't say fire companies and an arts council or an organization. It says an arts council on Main Street in Westminster.
I understand that, but what I'm saying is, since this requires legislation,
Right, would it be beneficial to
would
open
it
it
be
up a little bit more?
beneficial to
Expand it.
somehow
Well, The only other
make
organization,
it eligible for expansion, but I have no idea what.
Can I ask a question? I'm not familiar with this local legislation for Arts Council, but wouldn't the Arts Council qualify for temporary Class C licenses? Which, according to your rule, have no limit on how many.
Right,
They only have a limit on how long each event can be.
They are, and they do. They get their 40, through this license, they get 40, and then above 40, they do, you know,
1-day
60 more
licenses.
one-day licenses. We're trying just to make it easier, so we issue one license for the whole year.
Well, and actually to jump in on that real quick, not to like overly complicate the conversation, but the reason that that the Arts Council is not eligible for the Class C beer, wine, liquor license is because in the state law, there's a seating requirement and a dining room requirement for that. So they do not meet those requirements. So it's actually this section of the state law that allows them to have up to 40 events without those limitations.
and Dave, the only other organization that I could think of, and they never do, but maybe 1 or 2 events per year, is the Historical Society of Carroll County.
So for 2021, for instance, they bought the max license and the fee was $500, and then if they went over 40 events, they did a per diem license. So last year, about how much money did they spend in per diem licenses?
You have any idea of that? It's okay if you don't. We pulled a lot of numbers. I don't know that I asked her to look at that specifically.
I don't have that.
How,
How many events did you last year with alcohol?
I can only tell you how many we actually made sales at, because sometimes actually we sell
Right.
alcohol and
When
they
you
don't
When you
make.
sell alcohol, how many events did you sell alcohol?
55
Over the 40.
over the 40, yes.
So that's 95 events, right?
Yeah.
So
Okay.
you paid $50 for 55 days, is that right?
is that, I was gonna ask
Yep.
Joe, how many, okay, there you go.
It's $2,750.
Yeah.
Plus the license,
2,750,
what was the license?
500.
500?
So it's $32.50.
Yeah.
So if we just make a license for $5,000 and let them have it, is that it?
We should be
That'd
able
be
to.
the highest license fee for a nonprofit in Carroll County.
Yeah.
And just as an FYI, for the fire companies, this year is the first time I've ever had the fire companies purchase more than 10 events. I've got 2 fire companies that finally went to 20 events.
That's because they all got beer gardens now, where they never had before. All right, so if I understand your thing here right, $125 for more than 10 events per year, or not more than 10, would be a license.
Right,
$250 for 20,
right.
$375 for 30, $500 for 40, and it's blank for 41 or more.
Well, I'm open to board suggestions on that, but the closest license
$5,000, so.
that's akin to this, I think Joe pulled was $12.50, is that what it was?
$12.50,
Yes,
what we
$12.50.
charge for VFWs, American Legions, Elks, clubs.
Right.
So, nonprofit clubs.
Right. And this is a nonprofit.
Yes.
I think
Yes.
you
Yeah.
told me
Yep.
that.
Does the state statute require you to have certain seating requirements to be a full-time Class C license?
Yes, for a full-time Class C beer, wine, and liquor in Carroll, there's a dining room requirement, a regular seating capacity at tables, excluding seats at bars or counters for at least 50 individuals, and has a dining room is a separate requirement. So, I mean, I think you've been there. They do not satisfy those.
Candy, right?
Yes.
So all the VFWs and Elks and all that stuff will have dining rooms and stuff like that?
They all got Cs.
'Cause it sounds like ideally you should be a full-time Class C license.
Right, and we,
I agree.
yes.
Or we could-
What law is easier to change?
I got you. I understand.
Yeah.
So we charge them $12.50 to coincide with the
What the else?
closest comparison.
They have 95 events a year, or no,
Yes,
2021.
yes.
Budget person's not gonna be too happy with it.
Yeah, they're,
Our budget person.
No, it's just as efficient. Now Joe doesn't have to process a bazillion
I
one
agree,
why I
but
was
we're
asking.
also turning around $3,200.
We'll be losing
Oh,
$2,000
well,
in
yes.
fees if we change.
for a good cause.
If,
Need to come
last
up
year
with
was like.
Come up with a
next year, next
specialty
year.
license.
Well, I agree with
them.
that, and it's, you know, it's fact. However, to fully compare with the VFW and the Legion and so on and so forth, they don't have near as many fundraisers, in my opinion, as what the Arts Council does, which is a little different in my mind as far as fees go. What,
And true community events. I mean, these are events, you know, that are true community, like a community amenity almost, if you will.
What does the Art Council do with its money?
What does the arts, Gwen is okay, caveat here. Gwen is a newer employee to the Carroll County Arts Council. Lynn, who is the executive director, happened to be on vacation this week. She did let me know that she's available by phone and text if there are specific questions of her. But I said, don't worry, I'll front the specific questions. Okay, so what does the Arts Council do with its money?
Do they make grants?
Yes, the Arts Council, I do believe that they do scholarships as well.
Yes.
And they host and participate in a lot, like they do through the summer. They have community movie nights at the community college where like I could take my children and we could go watch a Disney movie in the evening.
Is it free admission?
It is free, yes, in the summer for the kids, yes.
They also do arts camps. I mean, those are paid. Like,
But the events,
pay.
when you have an event at the Arts Council, it's usually a admission fee, right?
Yes, usually there is some fee.
When you have music, there's a ticket.
Yeah.
Yes, sir. I mean, it varies depending on the event, right? But usually it's my experience, and I've actually been going there and involved and volunteered since I was a child. But it's been my experience that some of the events that are not perhaps as concert oriented or whatnot are much greatly reduced admissions fees than you would see elsewhere, you know, for the benefit of the attendees.
So you have events where you lose money.
Yes.
In fact, I would go so far as to say that perhaps some of the events, if not a lot of them, where they are obtaining these one-day licenses that they are right now, they're not even recouping the license fee. I mean, this is truly an amenity to people who are coming to these events. This is not like the draw for the event is
Right.
not because they are able to sell beer and wine.
what do they traditionally serve?
We typically serve 4 types of wine, 2 reds, 2 whites, and they come in the little individual, like,
Cost?
cost. It's,
Cost.
I think, $5 a glass, or, yeah. And then we also have, I think, 3 canned beers in our fridge as well.
And they have a few events throughout the year that might be a little bit more like cocktail party oriented, again, more towards the fundraiser side of things.
Do you rent it out for events that are sponsored by other groups?
The Arts Council is rented out. For example, we're having a rental this Friday by Lillian Stoneberger, who's a vocalist. She's just doing a vocal benefit concert, but most of our people that rent don't do alcohol through us.
Some do, though?
Yes, but we usually charge them for that.
Do you request the license for them?
I believe.
I'm
Do
gonna,
they do
we're
it?
gonna need to, I need to ask Lynn that question, because
yeah.
she's really the one who's suited, unless Joe has the answer off the top of her head.
Yeah, I don't know.
Yeah,
For example, I know we do the Carol Biz Challenge as well.
Okay.
Through the Chamber of Commerce.
yeah, I need to get specific examples for you, yeah.
Well, it's not a critical
You
question.
serve
it's just-
Bloody Marys at the county report, when they give the county report there?
State of the county.
State of the county.
If they don't, they should. That would be my
State
recommendation.
of the county
There
would,
comes that, Mister, there comes that Orange Mills. That wouldn't come from Carroll County.
I think they should serve cocktails at liquor board hearings. Particularly the long ones.
Mimosas.
I don't like them. Now, you wouldn't let me be on a liquor license because I'm on this liquor board, so how are you gonna serve me liquor on the liquor board?
Well,
One of
I didn't
those
have anything to
things.
do with
Sure,
that
we can
decision.
come up with a way.
Any other further questions?
What do you feel comfortable?
I'm just gonna say a number, $12.50, but I don't think it's a fair comparison.
You mean in a positive way or in a negative way?
I think it ought to be a minimum of 2,000. If we're charging $12.50 for that, I don't think it's a fair comparison as far as being a so-called nonprofit.
You mean, well,
I would like more information on what they do with the money, the
Yeah.
grants they make, whether, yeah, I mean, you can be a nonprofit, but you can also be generating income for various groups and through a grant system. I would just like to know more about that before you have a number in mind,
Hmm.
How
frankly.
many
Sweet
scholarships
number.
distributed?
I do not know. We can certainly get all of
NFL,
that specific information for you.
Yeah, I would like to know how many scholarships they give out and how they decide
Tax
those.
thing, of course.
Okay.
So basically, next month, just send me
We'll come
something.
prepared with some more of that financial information. I mean, from a more logistics standpoint, I would say that the request for this type of license would be akin to the Class C. So I understand, and we are not trying to get in at a lower number for the sake of it. But that being said, this is a nonprofit, just as if they had 50 seats, they'd be eligible to apply for a Class C license. The only thing at this point in time DQing them from the full Class C license is not having a dining room and 50 seats. So is it for that reason that we're then going to distinguish and say that this organization should be subject to a higher administrative cost? I mean, maybe the answer is yes, but I'll just put that out there for the board to consider, and we will come with some specific information to address some of your questions.
So I think the board, so I also speak for myself, I'm okay with changing the law.
Okay.
As you request. It makes a lot of sense. I think it'd be easier administratively and other things. I think it's the number that we fill in this blank. I think perhaps we want to clarify our thoughts, maybe.
That's my only question.
Okay.
I have no objection. I think it should be.
We appreciate that, and we appreciate the
I just use a number
opportunity
as a
to
number.
be here today, and I will speak with Lynn, and we'll get some more details on all of those questions, and if next month is the public hearing, or at whatever the next opportunity is, I will come prepared with some of that information.
Great, thanks.
You're welcome.
If you, perhaps in the essence of time, if you could get us that information prior to the hearing?
Yes. If I can find a consolidated way to confer that to you, I will absolutely do that via.
We don't need the balance sheet, we just
Right,
need.
exactly.
Just a better idea of how much money comes in and where it goes.
The annual report was actually just created this month and will be going out in a mailing. And as a nonprofit, our annual report will be up on our website.
Okay.
Yes, I'll get you the information.
Okay, good, thank you.
Thank you.
Okay, any other questions of
No.
this? Do you have anything else?
Unless you have something else for me.
Okay. Any other presentations or questions on the?
Thank you for this opportunity.
Yes.
We appreciate you all's input. We just thought that it would be good to discuss things with people that work with it, more so than what we do, before we have the public hearing, and try to come up with something that would be agreeable with the suggestions and comments and so on and so forth that you all made here today, that would make it easier for us at the public comment period, because you're probably the nucleus, certainly the nucleus of whoever's gonna show up for public hearing, so.
And I would note that there was not one grammatical error that was brought up today.
Well, there is one, but not,
But we didn't discuss
not
it.
out loud.
We didn't discuss it. Okay. If that's it, we'll move on to our routine business.
Thank you all.
Thank you.
Thank you very much, and
Thank you.
See you next
keep up the
month.
good work, and stay cool if you can for another day or so. And it's supposed to cool off a bit. Mister, we'll look forward to seeing you down the street from your office here after the 26th of this month.
Oh, yes.
The ponies will be running and the exhibits will all be there. And
I'll be there.
good. Look forward to seeing you.
Midway.
Out of it.
I'll be walking.
Thank you.
Bye.
Thank you all. Thank you very much.
Thank you.
What did I do with the finish? George, do you have it for me?
How about this?
Yeah. Is that your copy? I got one here somewhere.
I have another one. Yeah, I have another one.
I got it. Okay. First item of business is a one-day liquor license required for an outdoor event for Mount Airy Street Association to hold a wine and cheese on Main Street at the Plaza on Main Street, Mount Airy, on August the 18th.
At this time, I've talked to Mount Airy Police Chief, and he has concerns about this one. They are not closing the road down. I don't know what we want to do. If you want to approve it and pending the police chief approval,
So was this held before?
no, this is a new
It's a
event.
new one.
Do we have any diagrams or
Yes,
anything?
Joe's supposed to be. It's, the plaza's in front of Lurian's brick oven.
Oh, yeah.
Where?
Okay.
It's where the fire was several years ago.
Yes.
Right.
Lorenzo's, this is in Mount Airy. And then the rail yard, where the bike shop is, across from the caboose,
Okay.
okay? But the road, Main Street's not gonna be closed.
It's right, it goes right through that.
Yes, and people are supposed to walk from one, can walk along the sidewalk.
And who's sponsoring this?
Mount Airy,
Main Street Association? So like, it's like the,
They got two beer gardens.
yeah, it's like the Chamber of Commerce for,
Yes.
for that little area there. Business owners, retail, whatever.
Yeah. But with the street not being closed, the police chief has concerned. He was gonna talk to the county, to the town executive. He's not gotten back to me yet.
Do they need approval from anybody other than us?
No.
Really?
Because they're not closing the street down.
Okay.
Well, if they close the street, is that still considered a state route?
I don't think it is, but
Because of, the
Right.
bypass around there.
we have one coming, we do have one later on that they do close the street down, that they've done before.
In Mount Airy?
Yes. So I don't know how you want to handle this. I'm not sure the best way.
Why couldn't they get this,
Yeah.
why couldn't they get the street closed down this
They
time?
decide not to.
You just decided not to.
Who decided? The town or this outfit?
This outfit.
The outfit decided not to close
So
it?
they decided not to ask to close the street?
They
'cause
decide
you
not
have-
to ask to get the town to close down.
Well, that's not very responsible.
Right, and I have a problem with not having, if there's two beer gardens and people can leave the beer garden and walk to something else, to another area for another beer garden, without the road closed, I think it's unsafe.
Oh, that would be just common sense to ask for the
Right,
road
and
closed.
the police chief's gonna talk to the town administrator, he's not gotten back to me yet.
So it says here, the Mount Airy Main Street Farmers Market, under the auspices of the Mount Airy Main Street Association, is doing this event, promoting fresh and local in downtown Mount Airy.
Cause it's wine and cheese.
Oh, so there's more than just the wine and cheese?
Yeah, if you keep on,
Okay.
there's a whole list of vendors,
Oh,
and then there's a map.
it's wine and cheese.
Is that the day
Just
of the
wine and
farmer's
cheese?
market every
That's all I see.
I don't know.
I know they have one.
Is there anything other than wine that they're proposing?
I think there is one brewery.
Okay.
Well, isn't that brewery in that building they want to tear it down there?
That's not open yet.
Not open yet?
No.
So here they're having cocktails and ales place. That's in the plaza?
That might be at the,
There is a distillery right there, isn't there?
Yeah,
there's
I thought there was.
miscellaneous distilleries right there in the plaza too.
So they want to,
Here is this is the plaza,
yeah,
okay?
Right.
And then,
right.
That's all the diagram you got. It's not
Oh,
one back.
there's one,
That's it.
It's not one there.
there's, and
So
then
my question is, what is,
down here is the, what they call the rare garden.
where, is that the caboose down there?
Yes, the caboose is here.
Well, where's the road go
37,
through?
Right here, Main Street.
Right there. So here's the
Okay.
plaza that they
Right.
want.
Yes.
Here's Main Street. And then they're gonna have events on this side
And
and,
events at 30.
and where is this thing? Or is this just gonna be, they actually have a distillery that's on Main Street?
Yeah.
Is that what that is? Miscellaneous Distillery and
Yep.
Liquidity Ale Works.
Well, miscellaneous distillery is here, 25. And the Liquidity Airworks is 38. I think they're supposed to be at the plaza.
So there will be distilled spirits here. Is that right?
Yes. Yep.
And of course, actually, I shouldn't say of course, do they have a liquor license?
Yes,
Yeah.
Lewin Ghost has a liquor license.
Yeah, okay. So I see what you're saying. So there are cocktails available from the distillery, right?
We got cocktails, ale, and wines.
I don't know how you
Right,
can
it's
have it
everything.
without closing the road down. I would think,
Not if we're going on the other side.
no, I would think,
So what is on the other side? You're starting to show us
The other side.
of the railroad garden?
Yeah,
It's-
that's P and F.
well, plus you have all this parking, is what people be
Well,
parking.
that's gonna be all closed off.
Oh, okay.
Yes.
Okay. So what happens across the street? So there's a lot of action right here.
Right, and then actually between 4 and 5,
Okay.
in that area down there.
What do you think that's going to be?
In the the winery's gonna be in the rare yard,
Oh, rail yard, okay.
that's the winery,
The Urban Winery.
Yeah.
Chief's vendor.
food truck. And then,
Well, I didn't read the whole thing in there, but they mentioned about wristbands. How are they gonna control that?
they're gonna be IDing people at the plaza.
So they give them a wrist, they have to come to the plaza, get a wristband, and then they walk around and
Correct,
get all their stuff.
yes.
Well, suppose they go to that rail yard first.
No
By
wristband,
this.
no wristband, no service, right?
Right. It's gonna be at the plaza. Doesn't say anything about at the rare yard.
Look at something up here.
Keith, I would think if the police have some reservations about it, I don't think we should pass it if the road's not closed.
Where are you, Pat?
I agree with you. But
We have
my
a-
question is, do you wanna pass it? Are you comfortable, if the police chief says he's comfortable with it?
If he says he's comfortable with it, I mean, I wouldn't have, you know,
'Cause, I mean, it is Thursday. I think the date, right, isn't the
It's
date?
Thursday, and they've advertised
What
250
is it, the
tickets that
18th?
are already sold out.
18th, yeah, it's a Thursday.
And it says, does that say from 6 to 8?
Yeah, it's only 2 hours.
Only 2 hours. What's the reason they didn't want to close the street? They didn't want to ask for that.
I didn't get in.
So I'm kind of curious, that's August 18th, and we're just saying this now? And they've sold tickets to this event without?
Yeah, they're sold out.
they're
Yes,
selling-
I mean, this is normal. Usually we see it
Yeah, we don't,
a couple weeks beforehand.
Yeah, but they're supposed to be at least 10 days, right?
Well, technically for an outdoor event, it's supposed to be 30 days.
30 days
The
technically.
regular licenses at 1 days or 7 days.
By our rules.
So when did we get, I don't know when we got it.
It's stamped.
Received July 19th.
So basically 30 days
That
before
was-
the event.
Yeah, so that was 30 days.
Yeah.
Why you been holding those long? I
Tips
think
certified
if the
volunteers.
As far as I'm concerned, if the police chief,
Yeah, I'm up for it.
did you see us, Tina, you wanna see it?
Yes, please. Thank you.
As far as I'm concerned, if the police department approve it,
You said 18th, right?
Yes.
So
it's
not-
okay
it's not
with me.
tomorrow.
If
Yeah,
he don't
if he-
approve it,
Next
You
Thursday.
said Thursday, I thought you meant tomorrow.
Next Thursday.
No, I said that's,
Yeah, I
that's a
agree. I would go by the
Thursday.
police
That's what I was
department.
confused about, that it was a
You-
Thursday.
I'd go by the police department. If they approve it, fine. If they don't,
Tina says they've sold out the tickets.
that's their
Yeah,
problem.
That's their
they have a
problem.
big, posting online of who all's gonna be there, where all you can go to, what all they can do.
But so we did receive it in a timely fashion, right?
yeah, we
Yes.
did receive it within the 30 days.
Well,
So check-in begins at the Lorenzo Brick Oven Cafe at
That's the plaza.
okay, is that the plaza?
so several of those members have liquor licenses so people can drink in the establishment anyhow, no matter what we do.
Yeah.
There's a distillery there.
Well, the distillery's not, the distillery has no on-site drinking.
Yeah.
The Lorenzo's is the only one that has a liquor license that allows on-site drinking.
Where's Superfoods? Is it close?
I thought they
Yeah,
closed.
Superfoods, okay, Superfoods, forgot about Superfoods. The brewery's not open yet.
And then they have.
And then the wineries, I don't know where that winery's coming from. I mean, probably Frederick County.
They have Elk.
So it's to promote local produce and local
Only
farming, right?
Yeah, but Elk Run.
Well, their website has a whole list. They have Elk Run Wines, Low Vineyards, Old Westminster Winery, Linganore, the Urban Winery of Silver Spring, and Miscellaneous Distillery. Were all set up along Main Street to allow sample and sell of their bottled products.
You buy a ticket,
You get a wristband and probably a glass,
okay,
and then you can walk around and sample. But my understanding is the only two sampling areas are the
The plaza.
and
Over
the
there.
rear yard.
It's a 2-hour event. There's giving samples. Are they giving full pours of wine? Does anybody know?
No, those little cups. Right
Yeah,
there.
okay.
Half ounce. I mean,
But can they buy cocktails there?
Well, the distillery,
if they said they could sell, yes,
they're a vendor. They had the distillery as a vendor, right?
yes.
But they can't consume the product under that license that they have.
But they're going underneath the one they license now, they can.
Okay, so the distillery can sell a bottle of vodka if they distill it, and then someone can walk out into the plaza and just guzzle a bottle of vodka.
They can sell bottle of wine,
Bottle of wine?
bottle of wine.
bunch of winos.
Tip certified personnel will be checking ticketed attendees.
I think we have to go by what the
Civil Air
police
Patrol
feel.
crossing.
Well, I don't know.
I mean, if the board asks, I can also be there too.
Do we have criteria specific for one-day license?
No, not along those lines of,
I mean,
street.
I mean, we have,
As far as security and
we
area and all
don't
that.
have written rules, but we have rules that we go by. They have to have
Well,
ID
what-
vans, they have to,
what I'm getting at, do they have to, we don't have a check sheet that they gotta have this, and this when they apply.
No,
Perhaps we should.
we just tell,
yeah.
you know, if you're applying for outdoor, you have to provide a letter and a diagram.
Yeah, well,
But that's all.
what I'm getting at, we're involved with public roadways here. Maybe we should have security, you know.
So it's a Thursday,
Kind of thing.
Thursday,
So Thursday.
6 to 8.
6 to 8, 2 hours.
Correct.
I'm less concerned about the drunk people under those circumstances. You know, the wines are samples, and drunk people going out into the road.
My two concerns are, yes, if we allow this and with open road, I think that's gonna be, we're setting a precedent that we're allowing. And also the chief is not comfortable with it right now. He has not said not to, he has not told me not to say, don't do it, but he's also has not gotten back to me. My point is, if the chief says not do it, I don't think the board should do it.
I agree with that. But the chief also might be uncomfortable because he might have to deploy more people just to provide
Well,
safety,
I
that
mean,
little corridor.
There's a lot of politics involved, yes, and that he's appointed, and if he makes, you know, he's talking to the town executive to make a decision.
To the who?
The town, the mayor
Oh,
and
the
the town
mayor,
executive.
oh.
Yeah, I don't know what the exact term for town administrator, I don't know what the term is for,
Whoever.
Yeah, I would say, if he recommends that we do not grant it, then we don't grant it. But if he does, if he's not willing to make that recommendation based on all the considerations that he's more aware of than we are, then my vote would be to grant it, subject to his, veto.
I think we agree that the police chief
I'd leave it up to him. I wouldn't grant it.
agrees with it.
I would wait to
will
see what he
grant it.
says.
If he doesn't,
okay, I'll leave it up to him, do you want me to attend it?
if it's granted.
Okay.
But if he's not willing to pull the plug on it,
I might pull the plug on it.
He's not gonna pull the plug if we grant it.
I'll talk, I'll get a hold of the chairman and.
no, I would like him to say, I don't want you to do this. If he's not going to say that, then my vote is to grant it. If he's not willing to say, please, gentlemen, do not do this,
So Keith, why can't they ask for the road to be closed?
I don't know.
well, they can, but
Can't we stipulate that they need to do that?
They can't,
Well,
I mean, you can stipulate, and I don't know if we have enough time if
I think time's a problem here, but if he's got officers at each end to kind of direct traffic to ensure safety or something like that, rather than close the street, because it's Thursday, 6 to 8.
yeah,
it's a small window, it's a weekday.
Yeah, it's a little different than be Saturday
okay.
or Friday night.
Well, you'll have one coming up that week.
All right, well, let's
Okay, well, we'll approve it pending approval of the Mount Airy Police Department, okay? One-day liquor license request for an outdoor event from the Kiwanis Club of Westminster hold a beer garden with wine. Event at the Westminster City Park on September 22, 25. Question,
Fall
is
Fest.
that Fall Fest?
Fall
Have they
Fest.
done this before?
Yeah.
Several
Did it
years.
last,
Yeah.
yeah.
And we've actually brought them in one time before,
I remember, that's why I asked.
The Kiwanis?
City Rec,
Oh.
they used to do it.
So at Fall Fest, this is a fraternal club that wants to have a
Yeah.
beer.
Kiwanis Club.
Okay, yeah.
Any objection?
No.
One-day liquor license request from Chase Stem of Mission 1042, Inc., to hold an outdoor festival at the Carroll County Farm Museum on August 27th, from 11 a.m. to 6 p.m. What is Mission 10-42?
It's a police support organization. The 1042 is end of duty.
Right.
So they support military and first responders that want to get out.
So Chance
This is
Stem,
the one that says, you seen the sign say Summerfest?
Mm-hmm.
This is the Carroll County Summerfest. This is,
oh, okay. And they have, they're having music and they have all kinds
They
of
have
stuff.
some big time bands, yep.
Right. And did they give us comp
What, you
tickets? Did
Salem Mountain Boys?
they give us comp tickets?
No.
Okay, and,
What are you laughing at?
Yada.
Tim don't know who they are.
I know who the Santa Monica
No.
is, right?
I don't know.
I was a neighbor for one of them.
Any objection?
no.
I'm gonna tell you that one.
What?
He's going to that one.
This is actually the second year they've done it.
It's probably some kind of special food there that he likes.
Yeah,
So
something he likes there.
You know, he asked if he should attend the other one, but he said, I'm attending this one.
I could chaperone Keith if you need me to.
One-day liquor license request for an outdoor event from the town of New Windsor for their musical in Maine. They've had that in the past. Any objection?
No.
And they are closing the road.
No.
One-day liquor license request for an outdoor event from the town of Mount Airy to hold a town block party downtown on August 27th.
And they're closing the road.
Well, that's the same time as the thing at the Farm Museum. Any objections?
No.
Keith,
No, sorry.
are you attending that?
No, I'm attending Summerfest. I'm a designated driver.
What? Designated driver?
For who?
Cheryl.
Not your daughter, she ain't old enough. Permission to request from Charles Zimmerman, post commander, well, the VFW wants to have a
Cornhole.
cornhole tournament outside.
Done it, they've done it in the past. It's-
Any questions or objections?
Nope.
No.
You got a new, original floor plan and a current floor plan from 1623 Brewing Company.
They've added a new bar. It's highlighted in yellow.
It's installed already? Have you seen it?
You mean you haven't been there yet?
He's probably sat at it.
They'll soon have that whole complex on that corner.
Yeah,
In yellow?
Yep.
Yeah.
they're doing good business.
It's a seltzer bar.
Oh, wait a minute.
What?
That's been there. That's been there for a while.
Yes, it's been there for a while.
Okay.
It's seltzer. They sell seltzer out of that. That's the seltzer bar.
You want to see this, Tim?
That's just to bring us up to date, right? We don't have to take any action on that. Request from Frankie's Bar and Grill to change their license from a B to a BR to be open for one meal a day, only with list of proposed new hours.
Yeah, they're having problems, have enough, they don't have enough people to come to the bar for lunchtime, so it's cost effective to go to a BR restaurant license.
When's the last time they were checked?
For clients,
Yeah.
I don't know, I can find out, I don't know off the top of my head. I mean, if anybody has a sheet, it must be probably on the sheet. That's,
21.
no, that's the DUIs.
Probably further back.
Want to see this?
Any
Request new
objections?
hours?
No. Here, here, come on with the beer. Reese Fire Company requesting permission for outside service of alcohol in their carnival grounds for their big money drawing this weekend. They've done this for I don't know how many years.
And they forgot to submit to us.
Any objections?
No.
Letter from Brian Naylor of County Line Cantina informing the board that they will not be reopening, and they got a sign on their door or the thing over there says
They're
closed.
closed and for sale.
He does say he might have a buyer for the business.
That's good.
Any other business before this august body?
To answer your question about Frankie's, February 28th,
Second, wait, you might be right.
it was in February this
That's
year.
all right, I was just curious if
Was it
they were
February
checked,
this year?
that's all.
February 8th.
Anything else on the agenda?
Nope. I have something for once we're off the air. but-
Okay, well, there's no other business. May I remind you that our next meeting will be the third Wednesday, September the 21st, at 10 o'clock in this room. There are no other business to be brought before this August, wait. What are we gonna do with all the stuff that we discussed here this morning? Are you all gonna compile that because we're having the public hearing at the next meeting? Is that it?
Well, I think we have some questions that we need answered.
Well, that's why I'm asking.
Yeah, we,
Oh, you wanna go for lunch and come back, or do you wanna try to get,
because there are things that you guys are gonna have to make a decision on, the direction you wanna go.
So we go to lunch and come back?
Okay.
Is that all right with you? Mr. Tim, all right with you?
Sure. I'm here all day.
All right, well,
But now, when we come back, we don't need to be
we don't need,
On record.
video, on record.
Yeah.
Right.
so this meeting is
Adjourned.
technically officially adjourned. This meeting is officially adjourned. We'll reconvene on Wednesday, September the 21st, 2022 at 10 a.m. in this room. Meeting adjourned.